Welcome to our deep dive on finding expert legal counsel for adjustment of status in the United States. In this video, we will clarify why expertise matters more than location when you truly need a lawyer, and how to systematically vet the right attorney for a family-based AOS case. To guide you smoothly, we will proceed step by step, and we will include quick knowledge checks along the way. Let us begin by setting clear expectations with a brief agenda. Here is today's agenda. First, we will cover a concise disclaimer and scope. Next, we will explore the controversial insight that location matters less than expertise. Then, we will examine when you do and do not need a lawyer. After that, we will show you how to vet potential attorneys effectively. Following this, we will discuss fees, transparency, and common red flags. We will also review visual process maps and practical checklists. Finally, we will reinforce learning with short quizzes and then close with a summary and clear next steps. Before we proceed, please note that this content is for general educational purposes only and does not constitute legal advice. Immigration matters are highly fact-specific, and your circumstances may require a unique legal strategy. Therefore, consult a licensed immigration attorney for guidance tailored to your case. Watching or relying on this video does not establish an attorney-client relationship. With that clarified, let us move on to the central insight of today's discussion. Here is the controversial insight. While immigration law is federal and representation can cross state lines, the critical factor is not where the attorney sits, but how deeply they specialize in adjustment of status cases. Too often, petitioners prioritize the cheapest remote counsel rather than proven competence. Therefore, you should focus on practitioners who work on AOS day in and day out, and who can show results in complex family-based matters. With that foundation, let us visualize how to compare location and expertise. In practical terms, location is a minor variable compared to demonstrated expertise. Focus first on whether the attorney handles AOS cases every single day, including responding to requests for evidence and notices of intent to deny. Next, ask about outcomes and how they mitigate risk in borderline cases. Additionally, verify the attorney's license and disciplinary history with the state bar. Finally, assess communication practices and turnaround times. Now that we have clarified the importance of expertise, let us determine when you can safely manage a case yourself and when you should retain counsel immediately. When it comes to representation, not everyone needs a lawyer. If you have a straightforward case, such as a short, clean marriage, lawful entry, no immigration violations, clear finances, and robust bona fide evidence, you may complete the process yourself. However, once any complexity arises, such as prior criminal issues, immigration violations like overstays or unauthorized employment, complicated marital histories, or difficulty proving a bona fide relationship, representation becomes critical. Even a single mistake can trigger costly delays or denials. Next, let us map the decision process visually. This flowchart shows a practical decision path. If your case is simple and well documented, you may consider do-it-yourself filing. That includes carefully following instructions for the I-130 and I-485, preparing a robust evidence packet, and rehearsing for the interview. Conversely, if there is any uncertainty or complexity, move directly to hiring a specialized AOS attorney who routinely mitigates risks from requests for evidence and notices of intent to deny. Both paths ultimately converge at the interview and final decision, but the risk profile differs significantly. Building on that, let us compare DIY and professional representation side by side. Comparing DIY to hiring counsel reveals important trade-offs. On the DIY side, you may save on fees and maintain direct control, which works well for straightforward cases. However, it requires meticulous organization and patience. On the attorney side, you gain risk mitigation, strategic handling of complex histories, and professional curation of evidence. This is especially key when prior criminal matters, immigration violations, or complicated relationship histories are present. Additionally, counsel can provide interview coaching and escalation strategies if complications arise. With that contrast in mind, let us learn how to vet potential attorneys systematically. To vet effectively, begin by shortlisting 3 to 5 attorneys who practice immigration law exclusively. Next, schedule initial consultations and request flat fee proposals that clearly define the scope of work. Then, ask who performs the substantive tasks and how quality control is handled, rather than allowing sensitive details to be delegated to inexperienced staff without oversight. After that, Independently verify the attorney's license and disciplinary history through the state bar. In parallel, avoid unlicensed consultants or notaries who unlawfully practice law. Finally, evaluate the communication framework, including response times, regular updates, and whether there is a client portal. Now, to make this concrete, here is a practical checklist. Use this checklist during consultations. Ask about monthly AOS volume to confirm specialization. Clarify who drafts and reviews your forms to ensure attorney oversight. Request a flat fee with an explicit scope so you can budget accurately. Discuss how they handle requests for evidence and notices of intent to deny to gauge their risk strategy. Obtain the attorney's license and bar number to verify status. Finally, confirm the communication policy, including update frequency and expected response times. With the checklist in hand, let us address fees and transparency more explicitly. On fees, clarity is paramount. Prefer flat fee arrangements that define milestones and deliverables so you can manage expectations and costs. Insist on a written engagement letter that spells out the scope of services and exclusions. Be cautious of upsells that lack a clear legal rationale and avoid anyone who guarantees an approval outcome, which is not possible. Additionally, clarify refund and withdrawal policies in writing. Now that we have covered expectations, let us visualize the information flow among stakeholders. This sequence diagram illustrates how information flows during a typical AOS case. First, the client completes intake and receives a document checklist. Next, the paralegal may draft forms under the attorney's supervision. Then, the attorney reviews and finalizes the packet for filing with USCIS. After filing, biometrics are scheduled. If an RFE or NOID arrives, the team enters a loop where the attorney sets strategy and the client supplies additional evidence. Following that, the attorney prepares the client for the interview. Finally, USCIS conducts the interview and issues a decision, which is communicated back to the client. Understanding this flow helps set realistic expectations and keeps the case organized. Now, let us translate this into actionable hiring steps. To operationalize your search, begin by documenting all key facts. Entries, status history, marital history, any arrests or citations, and prior immigration filings. Next, shortlist 3 to 5 attorneys who practice immigration exclusively. Then, schedule consultations and bring a concise fact summary along with targeted questions. After those conversations, request flat fee proposals that specify scope and timelines. Independently verify the attorney's bar license and any disciplinary history, and review third-party feedback. Finally, select your attorney, sign the engagement, and begin with a document checklist to accelerate drafting. With the plan in place, let us confirm your understanding with a quick quiz. Quiz time. The question is, which factor should matter most when choosing an adjustment of status attorney? Option A, their physical location. Option B, their hourly rate alone. Option C, their specialization and track record in AOS. Option D, the number of social media followers. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is specialization and track record in AOS. Expertise, demonstrated by volume, outcomes, and risk management, is more predictive of success than location, standalone hourly rates, or social media presence. Now, let us reinforce this with a second question focused on risk triggers. Here is the second quiz question. Which scenario most strongly indicates you should hire an attorney? Option A, you entered lawfully, have a short marriage, and strong joint evidence. Option B, you have a prior overstay and limited joint documentation. Option C, you prefer not to read USCIS instructions. Option D, you are comfortable filling out forms. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is having a prior overstay and limited joint documentation. These are classic risk triggers that call for specialized representation to mitigate potential denials or notices. Now, as we close out the learning checks, let us set realistic expectations for your journey. To manage expectations, remember that processing times vary widely by field office, so plan for several months or more. Requests for evidence are common and should be treated as structured opportunities to strengthen your case. Interviews test both your documentation and the credibility of your testimony, so practice consistent, truthful answers. Maintain alignment across forms, supporting evidence, and what you say at the interview. To consolidate what we have covered, let us present a quick Markdown recap you can screenshot. Here is a concise recap in Markdown format. First, prioritize expertise over location. Second, vet attorneys by specialization, flat fee transparency, bar verification, and communication structure. Third, hire counsel if criminal or immigration violations exist, if marital histories are complicated, or if bona fide evidence is thin. Fourth, follow the standard process from intake through decision, staying organized and proactive. Fifth, keep the checklist, decision flowchart, and timeline readily available as your working toolkit. Finally, let us summarize and close with next steps. In summary, focus on expertise by selecting attorneys who handle AOS routinely. Pursue a do-it-yourself approach only if your case is genuinely simple and well documented. Apply the vetting checklist rigorously, and independently verify bar status and discipline. Prefer flat fees with clear scope and regular updates. Lastly, anticipate RFEs and interviews, maintaining consistent, credible evidence throughout the process. Before we wrap, here is how you can support the channel and share your insights. Thank you for watching. If you found this breakdown useful, please like the video, share it with someone beginning their adjustment of status journey, and subscribe for more practical immigration guides. In the comments, tell us, what is the single hardest part of finding the right attorney for you? Your experiences help the whole community. See you in the next video.